I'm Diane Birnholz. Closing arguments have finished in the Trump attempted assassination trial against Ryan Routh, who represented himself throughout his criminal trial. The judge admonished him during his closing argument for meandering way off topic, just as happened in various other parts of the trial. The jury is now out for deliberations. And as I mentioned in my last video, when I was a federal prosecutor, I had a trial against a defendant who similarly represented himself. And the judge in my case told my bank robbery defendant that he was not going to tolerate the trial being turned into a three-ring circus, much as the judge did here in the Ryan Routh case. Now, the judge in my case appointed the defendant an advisory attorney who was the very same attorney at the public defender's office who'd been appointed to him as his counsel in the first place. Now, the advisory attorney in my case just sat there and helped the defendant during the trial if he wanted it, but the attorney didn't actually do any of the talking at trial. The defendant did all of it. And the judge did something similar in the Trump attempted assassination case. So that way, if things really get out of hand with the defendant and the court can no longer allow him to represent himself, that advisory attorney would be able to step in and take over the case without delaying the trial or causing a mistrial. Now, another issue that we encountered in my bank robbery case is that the defendant chose not to testify. And that's fine. Of course, a criminal defendant has the constitutional right to testify or not. However, what you can't do is then give a closing argument where you're in essence testifying without being placed under oath and without being subject to cross-examination. Okay, that's not okay. So when my bank robbery defendant started doing just that in closing argument, so he was talking about things that only he could know, like describing where he was or what he was doing during the bank robberies, basically providing himself with an alibi. The judge admonished him to stop testifying during his closing and to only argue matters that were actually in evidence at trial. Ryan Routh also chose not to testify. Another unusual aspect of my trial was that I had a bank robbery defendant cross-examining my government witnesses. You have the same thing in the Trump attempted assassination case. So, for example, I had a victim bank teller on the stand, and the defendant asked her things on cross like, "So, did the bank robber hand you a demand note?" And she would look right at him pretty fiercely, and she would answer, "Yes, you did. Yes, you did this, you did that." And it did not work well in the defendant's favor, in my opinion. And in my case, one of the bank robberies in particular was hotly contested because we were charging that the defendant had made an express threat of death in just that one robbery, which would be an enhancement to his sentence. And we had a surveillance photo from that robbery that clearly showed the bank robber in profile. Now, in closing argument, the defendant held up that surveillance photo right next to his own face, and he said to the jury, "Look, that's not me." And I could just see the jury looking back and forth between that surveillance photo of the robber's profile and the defendant's own profile live in court. And I'll tell you, all that the defendant accomplished was making it crystal clear that that photo was most definitely his own face. The jury quickly convicted him on all the bank robbery counts, and he appealed and brought many habeas petitions, but his convictions were affirmed. We will see what happens in the Ryan Routh case. We've still got the jury out. Thank you very much.